Ladies and gentlemen, my team and I welcome you to the prestigious University of Maastricht. Today we'll be filming our first edition of interviews, and our guest will be Professor Peter van den Bossche, who has been the longest exercising judge at the Appellate Body in the WTO. Good morning, sir. First, thank you for having us. Professor van den Bossche, first could you please introduce yourself, meaning your professional and academic career, as well as your role as a member of the Appellate Body in the WTO?
First of all, thank you for having me and interviewing me.
Pleasure.
I never pass on an opportunity to preach the gospel. My name is Peter van den Bossche. I am currently Director of Studies at the World Trade Institute in Bern. But between 2009 and 2019, so close to a decade, I was the European judge on the WTO Appellate Body, as you already indicated. During my professional career, I've been going in and out of academia, or perhaps in and out, the other part, European and international adjudication. I started my professional career as a researcher at the European University Institute and a staff member at the European University Institute in Florence, and then worked as a referent there at the European Court of Justice. After that, I joined the staff of Maastricht University for a couple of years, and then I was very fortunate to be one of the very first people recruited by the Appellate Body. So I was a senior lawyer at the Appellate Body Secretariat, which, as you may know, is a separate secretariat from the WTO Secretariat, because it only serves the Appellate Body members. At the time, the Appellate Body Secretariat was very, very small. There were just 4 lawyers, a director, senior lawyer, that was me, and 2 junior lawyers. Compared with the Appellate Body Secretariat that was there in 2019, when the Appellate Body became paralyzed, and we'll talk about that later undoubtedly. Then we had close to 20, or the Appellate Body Secretariat had close to 20 lawyers. So it sort of explains how much more case law, how much complexer the cases became. I also served then, before returning to academia, I served as director of, acting director of the Appellate Body Secretariat. That was the very, very early this millennium. But I decided to return to what my wife used to call a saner life, so less crazy, and to go back to academia. So that's what I did. It's then that I started working on a textbook on WTO law, the law and policy of the World Trade Organization, which was published by Cambridge University Press, and of which the 5th edition now just came out. I received a copy the day before yesterday. So, Cambridge will tell you, I'm too modest to say that, but Cambridge will tell you that it's the best-selling textbook.
We have one.
You have one?
Yes.
Oh, that really pleases me. I was then a professor of international economic law here at Maastricht University, where you're a guest today, and I'm a guest today. Until I was nominated by first Belgium and then by the European Union for Appellate Body membership. That was 2009. Then I served 2 terms.
For each?
For. But since there was nobody to take over from me, I was mandated the rules provide for that. You can be mandated to finish the cases on which you had been assigned before the end of your term, which in my case meant that I had to, well, I was going to say I had to.
So you're still working on a lot of cases?
For a year and 3 months in addition. So you're looking at the longest serving appellate body member ever. Because, yes, this is, by the way, something the United States was very unhappy about. The fact that, although it was completely within the rules, one of the things that they complained about quite bitterly was that I was allowed to finish the cases I was working on. And perhaps that had something to do with the fact that the last case that I finished, and in which I was the presiding member of the Appellate Body Division, was the US Boeing 21.5 case. This case concerned the subsidies that the United States allegedly gave to Boeing. And this was already a 21.5 case, an appeal in a 21.5 case, so that means that it was a compliance case. United States, in implementing the first ruling in US Boeing, the United States had done a number of things. The European Union did not think it was sufficient. It was not proper implementation, so we had a compliance case. But let me not get buried in all these details. I am now, since I retired from the appellate body, I'm a director of studies at the World Trade Institute, which is.
And you like it better in the academic field or in the appellate body?
Oh, that's a difficult question. Well. I love adjudication, and I will continue to be involved. And I'm an arbitrator in under a number of agreements. But almost a decade on the appellate body is enough for anybody to. So it was very nice to be back in academia and to be able to say what I wanted to say, because for a decade I had to be very careful in anything I said. And then still, I mean, there are a number of things that I would want to say, but which fall under the confidentiality obligations. No, it's nice to have to refine one's liberty.
Clearly. And since the creation of the WTO to this day, what are in your views the greatest achievements and the worst failures of the organization?
Well, the greatest achievement over the last 2 decades plus is undoubtedly dispute settlement. And that is not because I've been involved in dispute settlement. That's an objective statement. The dispute settlement system of the WTO is, in terms of international dispute settlement, the settlement of disputes between states, state-to-state dispute settlement, is a truly unique system. It goes far beyond other systems. And many of you may now think about the International Court of Justice. Well, I think WTO dispute settlement has features that beat the International Court of Justice, and I could give you a 2-hour lecture on this, but I will spare you. Now, of course, there are also shortcomings to this system, yeah? But it has been a very successful system. It was actually, until not that long ago, referred to as the jewel in the crown of the WTO. And I think correctly so. And it has been, it was the envy of people that worked in other fields of international law. Yeah? So often I met colleagues that are specialized in international environmental law, international labor law, and they said, if only we had a dispute settlement system that was compulsory, that was binding, that was... as you people have, well, we would be much better off. Yeah? They don't. The field in which they really have been looking at international at the WTO dispute settlement system is the field of international investment law. You may be familiar with the fact that the international investment dispute resolution is very, very much has been the subject of much controversy for various reasons. Who are the arbitrators? It seems to be a very small group of people that sometimes function as counsel, that sometimes function as arbitrators. So it's do I dare to use the word mafia? No, I didn't use that word, but I mean, so it's contested in that way. It's also contested in the fact that on the same issue, one ICSID, primarily ICSID tribunals, one ICSID tribunal would decide the issue is black, and then shortly afterwards, another tribunal, it's white. Well, this is there's a complete lack of consistency, and what you saw happening, and the European Union is one of the drivers in that process, is the establishment of an appeal level, an appeal court. And the European Union has done that in a number of its agreements, in the CETA, the agreement with Canada, the agreement with Vietnam, and I'm now forgetting at least one other agreement in which they are planning for a global investment court system with 2 levels. And it's a copy-paste of what happens in the WTO. So in the investment field, this kind of dispute settlement system is really making progress. It's being copied, while it's in a big crisis at the WTO. The number of disputes that was brought and was decided is, if you compare it with comparable dispute settlement systems, so state to state. So you've been talking about the International Court of Justice, but perhaps even more the ITLOS, the International Tribunal on the Law of the Sea. Why? Because that's a court system that deals with a limited field of international law, just like the WTO. Well, if you compare the productivity of these systems, you have the WTO here in terms of number of judgments. We call them reports, but they're judgments. The International Court of Justice here, and ITLOS there. I don't know whether the camera follows my hands, but this is, and it has been used by developed and developing countries. The very beginning of the system, I had people approaching me and they said, oh, well, this dispute settlement system of the WTO is going to be used by developed countries to push down the throat of developing countries the new WTO obligations. Well, no. And there are cases brought by developed countries against developing countries, but developing countries have also brought cases, small developing countries have brought cases against the economic giants of this world and have won them. Yeah? Developing countries have also been bringing cases against each other. There was a time that any self-respecting Latin American country seemed to think that they had to bring a case against a neighbor. Otherwise, they were not really. No, it has been much used. And the last comment, the compliance record. You got a ruling, but does then the losing party comply? Do they change their legislation? Do they withdraw the measure that is found WTO inconsistent? Yes. Yeah. If you ignore the last 2 years, the compliance rate was anything between 80 to 90%.
They are like penalty payments? Are they penalty payments?
Excuse me?
Penalty payments, or how does it work?
Well, let me What you do not have in WTO dispute settlement, and that for me that's one of the major shortcomings of the system, is that there is all the remedies are prospective. There are no retrospective remedies. So the damage that is caused before you have a ruling of illegality, plus a reasonable period of time for implementation, so even further. None of these damages is to be repaired, yeah? Which is very different under standard international law. You have to repair the damages, you have to compensate the damages that you cause as a result of an illegal act. Not in WTO law, yeah? Because WTO law has contracted out of these customary rules of international law. That's the first point. So this is, for example, why it's very important that cases are done in as short a time possible. The other point is that, and there the WTO system is stronger than other systems. The WTO dispute settlement system provides for the possibility of, if there is no compliance, for retaliation measures, trade sanctions to be imposed on the country that does not comply. And this is I always call it the big stick behind the door. But in actually very, very few cases, that stick was used. Yeah? Partly also because if you're a small developing country that wins a case against a developed country, the stick is perhaps not as impressive, because what can a small developing country do vis-a-vis a big developed country? Whatever they were doing in terms of taking trade sanctions would probably hurt them more than it hurts the big economy. And there are examples of that.
Through all those cases, were there like particular cases that struck you as a appellate body member?
How long can I make that list? When I was a senior legal advisor to the Appellate Body Secretariat, we did some fascinating cases. I mean, my first case on which I worked was the wool shirts and blouses case, in which the burden of proof in WTO dispute settlement was set out. Which under all these, the GATT years, the previous system, panels had never really thought about who has the burden of proof. So that was fascinating. That's the very first thing on which I had the pleasure to work. Of course, I didn't decide. I was not a judge at that time. But then there was the E.C. Holman's case on which I worked, which was also fascinating. And there was U.S. shrimp, which is also often referred to, but incorrectly, as the shrimp turtle case. But U.S. shrimp is the official short name. I think these were the cases that really stuck with me from my period as on the Secretariat. As a judge, the EC Airbus case, and in particular the issue of prohibited export subsidies. That was, we worked for almost a year on that case.
Was that the same case with
massive. I mean, the panel report itself was, still have nightmares about the size of the panel report. Our report was 700 pages, which was a case brought by the United States concerning subsidies that Airbus, Airbus received from both the European community / European Union now, and for European Union member states. Subsidies they had received over a period of 40 years. So you can imagine, and the number of subsidies and the nature of subsidies varied very, very much from cheap loans to direct investment to research and development subsidies to infrastructure subsidies. So everything under the sun. If you really want to have a case where you can study virtually all aspects of the subsidies agreement, well, that's the case you should look at. So that was the most fascinating issue for me was export subsidies, prohibited export subsidies. The United States claimed that the European Union had received prohibited export subsidies. Their other claims were claims of actionable subsidies, which is a lighter crime to commit.
Could this case be linked with the Boeing case?
Yeah, well, they were. I mean, the United States at a certain point decided to bring this Airbus subsidies case, and the European Union retaliated in the sense that, well, if you challenge our subsidies to Airbus, we will challenge your subsidies to Boeing. And both the United States and the European Union, in their respective cases, were found to be violating the subsidies agreement. But this dispute was very recently, last summer, after 17 years of litigation, was put to rest. An agreement, at least temporarily. They pushed on the pause button for 5 years. Because there was a danger of an escalation of retaliation measures. There was an agreement reached really to turn their attention now to the subsidization of production of aircraft, large civil aircraft, by others, read China. That they would join forces to look into and challenge the legality of. I've always thought, I couldn't say that at the time, but actually I once made a mistake to hint at it, which was bad when I was a judge. But I always thought that while they litigated very fierce, the fight, Airbus-Boeing fight, was really very sharp. I always thought that in the end, they are really thinking about the future. Because Airbus and Boeing, they sort of shared the world market. Yeah? And sometimes one had 60% of the market, 40%. And it changed, but I mean, they could not possibly produce everything alone. So there was, but I think already from the very beginning, they were thinking about, well, although this was 17 years ago, this was still distant, but what if Japan and India and Brazil and Canada and China start subsidizing their large civil aircraft industry? And I don't know whether we haven't done much flying recently, but the Canadians have now, the Chinese have now, they have large civil aircraft, still in the lower 100 plus, but just a little bit plus seats, between 100 seats to 200 seats. So it's not the A380. Which is now no longer produced, I understand. But yeah. But anyway, I'm digressing. So that was one case that I so the other case is the USAD-CVD China case. That's the U.S. anti-dumping and countervailing measures case from China, in which the key issue was the definition of the concept, or trying to figure out what the concept of public body stood for. Now, again, that's a lecture in its own right. But it's, in one sentence, the United States took the position, still takes the position, that any state-owned enterprise, and think China, that any state-owned enterprise is in fact the government. Yeah? So that anything a state-owned enterprise does can be considered a subsidy. Because what is a subsidy is a financial contribution by a government or a public body. The United States says any single state-owned enterprise is a public body. The appellate body said, no, we disagree. Yeah? A public body is only that entity which actually is vested with governmental authority, with the mandate to pursue governmental objectives. And then, yes, I mean, many of the state banks are public bodies, but your state-owned steel producer in China is not necessarily a public body. This has been very, very, very controversial. I mean, I think it's one of these cases about which explain why we're currently in the crisis we are, because the United States took that very, very badly. Yes, I was on the first division that ruled on and there are people across the ocean that say that European, he is the one that
pointing you.
Well, I mean, which is nonsense, because decisions are taken by the division, and there was no dissent on that particular. I don't make any further comment. Am I still convinced that it was the right decision? Yes. Yeah. Although in Brussels they also have second. They're not that happy with that case law. No, which I find a bit difficult to understand given the number of state-owned enterprises in Europe. But this is no. They've sided with in a proposal for on industrial subsidies. There's a paragraph. It's a joint proposal by European Union, United States, and Japan. There's a paragraph in which it says that they don't agree with the appellate body's case law on appellate body. On public body. They don't agree on the appellate body's case law on public body. They don't say how they will resolve it, which I think is going to be the problem. Yeah, because I don't really see on the basis of the text that we have, because the appellate body had a very text-based interpretation. I don't see how you can. Now, it may not be the right thing, but let the members, the WTO members, then negotiate provisions that are clearer, that state what.
Were you maybe hoping that Brussels would support you in any way in terms of the decision that was rendered?
No. I mean,
not special.
This is honestly,
you don't.
I don't care.
Yeah.
And I should not care, and I've never cared. One hears, not directly, because when I was a judge, I had no contact whatsoever with. I had many friends in the commission. I didn't speak to them. Except for hello, how are you? Huh? Nice seeing you. Bye bye. Huh? At receptions, but even that, because I very, very seldom went to this kind of things for about a decade. Yeah? I'm now sort of getting reacquainted with many of them, but no. This is. If you take your job as an international judge seriously, yes, you're nominated by, but you're not sitting there for. Yeah. And if you want to lose the respect of your colleagues, and as you know, the appellate body is a very small court. There are only 7 judges. If you want to lose the respect of your colleagues and not being listened to anymore, then you take national perspectives. Yeah? So no. It's. I know that the European Commission was quite upset with the outcome of what is called the baby Bouillon case. which is official name is U.S. Baby bullying. Huh? No, it's a case in which the European Union claimed that certain of the subsidies given by the United States to bullying, subsidies that were not part of the big bullying case, were import substitution subsidies. And the appellate body ruled no, it's not the case, and they were very disappointed to lose that case. I was on the division. Yeah, I think my name was not pronounced in Brussels with great sympathy for some time. But you can't.
But it's not your main focus. Your main focus is that you go on and render what is just for you.
Hope that you're right.
Yeah.
And in a way you are right, because you're the court that has the final say. Yeah. So at the moment that one does not accept anymore that what you say is, for better or worse, the final word. Yeah. And, but did we always get it right? As an academic now, looking at certain decisions, I say, perhaps we should have gone. Certainly with, in retrospect, am I going to tell you which ones? No. Yeah, I mean, as I said in my farewell statement, I actually spoke some Latin there. Errare humanum est. We humans, we make mistakes. Human institutions make mistakes. And it's for a next generation of appellate body members who will undoubtedly be much smarter to correct these mistakes. So no, I mean, I think we did make our part of mistakes, but also often on the basis of new arguments were developed, sometimes in academia, sometimes in later cases by WTO members, that were not before us. Yeah? Not that we were limited to the arguments that were made, because as a court you're not limited on the law, you're not limited to arguments that are made. You're in charge of that yourself, but yeah, new insights develop, yeah? And that make me wonder whether, and I appreciate that you would want me to give some examples, but I will not.
You will not.
Not
it will not be for today then. Following that, in the light of...
Okay, but I didn't finish your question, because you asked me what went well and what went wrong, and we started saying dispute settlement, and then I started what went wrong, what failed in the WTO, and I think everybody will say that the negotiating function failed terribly. Yeah? So the function of the WTO to create new rules that are adapted to the 21st century, rules that are there to fix the problems that were not resolved in the Uruguay round. Problems dealing with the position of developing countries in the multilateral trading system. The WTO failed as a negotiating forum, because that was the idea. WTO would settle disputes, but also make new rules or fix the inadequacies of the current rules. That the WTO was a failure in terms of its negotiating function. I made a statement, but let me now put, as any academic would do, 2 or 3 footnotes. I think it's unfair to say that no, let me phrase this differently. I think that the WTO doesn't get enough credit for these negotiations that were successful. And there have been successful negotiations. This morning I read one of the headlines, so they hope to reach an agreement on the fishery subsidies agreement in the upcoming ministerial conference, which starts on the 30th of November. There seems to be more and more hope that there will be a breakthrough for that very important agreement. But the headline, well, no, the first paragraph said that this would be the very first agreement reached in the context of the WTO. Well, that journalist doesn't know what he's writing about, because honestly, there were a number of agreements that were reached. Yeah? There was an agreement on trade facilitation, the trade facilitation agreement, which was basically agreed at the ministerial conference in Bali. That was 2013. There was an agreement on the elimination of agricultural export subsidies, 2015. There has been an update of the information technology agreement, which was an original agreement, but which was, that one was first reached in Singapore, 1996, and was then updated quite recently and expanded, because obviously information technology products in 1996 were different from what we have now. You didn't have smartphones in those days. And there were the accession agreements, the accession of China, the accession of Russia. These were, in all respects, very, very significant negotiating successes. But people focus on, and not incorrectly, but they focus on the failure of the Doha round, the Doha development round, which started in 2001 and is dead and buried, although not officially, because in order to finish a round, you have to have consensus to finish it. And there is no consensus to finish it, not even that. Negotiating function is a problem, and I'm not going to go into the reasons why the negotiating function has great problems, because you're not asking that.
Maybe you have the main points.
Well, that's the problem with that question. Decisions need to be taken by consensus, at least in political terms, because formally the WTO, the Marrakesh Agreement says that decisions are taken by consensus, and if consensus cannot be reached, you can go to voting. But that's theory. Decisions are taken by consensus. That makes things difficult, very difficult. But I don't think that the solution to that is then to really revert systematically to voting. Certainly not on decisions that would create new obligations. Certainly not. I think the most important reason why negotiations are so difficult is because, first of all, the main players, which are the main players? Well, United States, European Union, China, India, and Brazil. At the WTO, these days, nothing moves until and unless these five have some sort of understanding. Well, it will be clear to you that these are countries with very different levels of economic development, very different economic systems, very different political systems. In the old GATT days, we had the Quad. That was the European Community at the time, the United States, Japan, and Canada. These were the ones that called the shots. We thought that there were huge differences between these four. We had no idea what huge differences really were. They were actually quite close to each other, and of course there were differences of interests, but we are now living in a much more complicated world with the last couple of years, also the reemergence of geopolitical confrontation, between the US and China. Yeah? That's one reason why it's so difficult. The other reason is something that we've always hoped for, which is now finally happening. Developing countries, and then I'm not talking about the big ones, the very big ones, but developing countries have found more and more a voice in negotiations. When the Marrakesh agreements were negotiated, so the workaround agreements, when they were negotiated, developing countries were in the room, but were not heard. Developing countries these days are heard, made themselves heard. It's not to say that there's no further need to improve, certainly when you talk about least developed countries, to improve their negotiating capacity. But they're working much more together. They pool resources, and that's a good thing. But on the other hand, it makes reaching a final agreement so much more difficult because there are more interests around the table that need to be taken care of. Yeah. Okay. So that's the. I think that answers your last question, the last question that you asked.
We went on so many, and we've left track of action. But following on to that, under the administration Trump, the U.S. delegate at the WTO blocked the renewal of the Appellate Body Members, following the U.S. standpoint that the WTO did not sufficiently consider or serve the U.S.'s interests. So now, how do you feel as if the situation has evolved under the Biden administration?
The Biden administration is undoubtedly less hostile to multilateralism in general, to international cooperation, is reaching out much more to what are traditionally its allies. And we see this, for example, in the climate change area. We see it also in a number of other fields, but we do not see it in the trade field. The Biden administration continues to block the appointment of new appellate body members.
The situation hasn't changed.
That situation has not changed at all. And almost every month there is a resolution tabled by often more than 120 WTO members to start that process of appointing appellate body members. The United States continues to block that.
Well, maybe the MC12 result and conclude no. You don't think so?
I mean, one can expect and probably expect too much of the upcoming ministerial conference, but dispute settlement, the problem will not be resolved. The best I would dare to hope for is that there's an agreement on a work program to resolve not only the institutional problems with dispute settlement, but also with negotiations. And monitoring transparency, that's a third issue. I was told, but I haven't seen the text because it's a confidential text, that the European Union and Brazil tabled the draft decision, a draft declaration to that respect, but that it was did not receive a very enthusiastic response. Yeah? So the most I dare to hope for is that a work program on resolving the problems with the appellate body and therefore the problems with the whole dispute settlement system, that a work program to resolve these problems is agreed upon. Right? So say, well, for the rest of, I think that from what I know, which is not much, I haven't seen the text, But from what I heard is that the declaration would see, well, the rest of 2022, or in 2022, we will have discussions, negotiations, and then starting early 2023, and up to the next ministerial, MC13, which is at the end of 2023, we will actually have text-based negotiations, which is the next step. First you talk, and then you have text-based negotiations. That's what the European Union and Brazil want to have as a work program. That's all we can hope for. Yeah? The Biden administration has, in terms of dispute settlement, they have indicated the new ambassador of the US to the WTO when she had her hearings in Congress. She has indicated that the United States may want to start talking about the future of appellate review. And that's a positive sign, but it doesn't it doesn't really it's very open and very vague, and so I think we'll have to see.
Well, that's on the surface.
What comes out. And for the rest on trade policy, the Biden administration has made it quite clear that they will continue the current stance of the United States vis-à-vis China. Yeah. And there still is a huge trade war. We seem to forget about that. There's a huge trade war going on between these two. Yeah? People say, well, no, wasn't there this phase one deal? And the phase one deal was just to avoid further escalation of that trade war. And as people in Chad Bow of the Peterson Institute for International Economics has shown, China has not met its obligations under that phase one agreement. Now, partly perhaps because of COVID, so no. In terms of trade, your question was specifically on dispute settlement. The Biden administration, the tone may be a bit different. You don't hear Biden say that he will withdraw from the WTO if they don't. What was the word again? If they don't change. You don't hear him say that. But fundamentally, there is, and I've got some sympathy for the Biden administration in that sense, because trade is toxic. If the Biden administration wants to lose the next Congress elections, and in 2 years and a bit, the next presidential elections, they're seen to be soft on trade, and any concession that they would make would be seen by part of the electorate, left side of the Democratic Party, and then obviously all the Trumpists or possible Trumpists would see as it's toxic. So I understand why the United States doesn't really want to
overtly express their opinion on the issue.
In that respect, I'm not very hopeful until we get into a second term for President Biden.
So following that, do you think the WTO mandate still makes sense today, knowing that we have to wait till the next MC12 in 2023?
Well, I mean, they will continue. The problems are there and have to be faced and have to be addressed. So there will be continued talk, and perhaps small deals can be made. But I think when one talks trade policy at the global level and what is possible, it's very important to see what is happening in the domestic politics of the big players. And also in Europe, now with the new government in Germany, and Germany being the predominant power, also trading power within Europe, we will probably see a different trade policy, which may not simplify things. So also that has to be watched very carefully. So what is the new German government going to do in terms of trade, in terms of sustainability of trade, if environmental sustainability? What is going to be their position on CBAM, the carbon border adjustment mechanism, which will be the most controversial issue the next couple of years. There will be a huge trade dispute on this, possibly escalating in mini trade wars. I mean, you already see it building up. And the Commission has tabled its proposal. They argue that it's all WTO consistent. And if I would be their lawyer, which I'm not, but I could make a good argument about WTO consistency. There is one major problem, but okay, that will go away with time, that problem. But this now has to go into the legislative process. Parliament has to have its say. The Council will have its say. And listening to some of the member states of the European Union and listening to what Parliament has already said, I'm afraid that the final form of CBAM will be less WTO consistent than the Commission's proposal. I'm pretty sure of that. Therefore, there was already vicious criticism of CBAM as proposed by the Commission. You can expect there to be, United States, Australia, China, they're all lining up and say, well, we'll challenge this. Well, they will have even more to challenge when the legislative process in Europe is finished. So no, this will be, that's why, two things coming back. We need a functioning dispute settlement system, and we need a negotiating function that works, because we will have to agree on new rules to allow trade restrictive action to realize a climate change agenda. These rules are either not updated, not sufficient, and we'll need to sit down and well, we, not me, but WTO members will have to come to an agreement. And you can only come to an agreement in the context of a negotiating forum, and the negotiating forum is the WTO. So if you are wondering about the future of the WTO, the question you haven't asked yet, I said, yeah, there is no alternative. And in the next couple of days, and certainly if the next ministerial is not a success, you'll read all sorts of headlines, end of the WTO, and this is a fatal blow. Well, things like that sell newspapers, but it will be a disappointment. But what alternative do you have than to carry on and to meet again and again and again, and try to come to negotiated solutions? The alternative is devastating. Because we would all go unilateral, and that would trigger retaliation, and retaliation would trigger counter-retaliation, and before we know, we have 10, 20, 30 mini trade wars.
And money being lost in
if you're looking for a way to destroy global prosperity,
that's the way to do it. And we were talking about COVID and the climate crisis.
Yeah.
From a WTO standpoint, national environmental measures are seen as a barrier to trade. Theoretically. So how do you think that the WTO will accommodate with the protection of the environment?
Well, first of all, trade is necessary in order to protect the environment. Yeah. The fact that there is trade in environmentally friendly products or services, the fact that you can actually buy machinery that is less polluting in a country where it is produced. You can try to produce it yourself, but perhaps you don't have the technology, or if you do produce it, it's of less quality and more expensive. So it's a very welcome thing that you can actually buy these things elsewhere, that you can import them. So I think do not see trade as the enemy of the environment. Often the environment and environmental protection will need trade. But you're right. In an environmental policy, one often has to take trade protectionist, trade restrictive measures. I wouldn't call them protectionist, but trade restrictive measures. I agree. And they then are always inconsistent with sort of the first level obligations, with the most favored nation obligation, with the national treatment obligation, with the prohibition on quantitative restrictions. But never forget that there is also the possibility to justify these measures that are otherwise WTO gets inconsistent. Under Article 20 of the GATT or Article 14 of the GATS. And there we have talking about the environment and talking about, for example, Article 20b, to the extent that these measures are necessary to protect the environment and do not constitute arbitrary or unjustifiable discrimination, these measures are justified. Yeah? It's sometimes a complex story. I mean, this is WTO law is international trade law is not for the faint-hearted. It's complex. Yeah? And they're not easy answers, yes, no, and this is prohibited, this is not. But trade law, WTO law, is not free trade and free trade above everything. No, it's much more about finding the balance, the right balance between free trade, which serves us well, yeah, and is often necessary, for example, to protect the environment better. Balance between free trade and other societal values and interests, which are often more important than economic welfare and trade. Yeah. I think nobody in his right mind would say that public health is less important than trade. Nobody in his right mind. Now, I know there are there are these free trade crusaders that think that liberalizing everything will save the world. But, I mean, this is not what the WTO is about. This is not what, if it were, I've wasted much of my professional life. This is, yeah. That's,
have you worked in cases where environmental measures were involved?
Oh, yeah. I referred earlier to the U.S. shrimp case, where the environment was very, very central. The protection of the environment was very central, and where initially this was very much forgotten by civil society groups at the time, but the Appellate Body ruled in that case that the measure itself, the legislation, was provisionally justified under Article 20G. Actually, the Appellate Body gave a broad interpretation of that provision, because it says that exhaustible natural resources do not only cover coal, steel, coal, iron, air, so minerals, yeah, which was definitely what the drafters of the GATT in the late 40s had in mind. Yeah? No, the appellate body said you have to agree to an evolutionary interpretation of the concept of exhaustible natural resources, and so that includes also living resources and in particular endangered species, such as the sea turtles. Yeah? So the appellate body said, okay, the measure at issue itself is provisionally justified, but the United States applied that measure in a way that constituted arbitrary and unjustifiable discrimination. Yeah? And that's why they lost in first instance the case. I've been more involved in cases involving public health, protection of public health. The U.S. clove cigarettes case stands out. That's a case in which I was a judge. It's a TBT case. TBT case in which we had sort of had to invent, not to invent, but we had to interpret the TBT agreement in such a way that there was an Article 20 kind of exception possible. But that would probably lead us too far. But that's actually another case I should have mentioned. I said, which cases have made most impression on you? I didn't finish my list there. But the clove cigarettes case, U.S. clove cigarettes case, where we introduced the legitimate regulatory distinction test in Article 2.1 of the TBT agreement.
To finish, would you like to say some words to the students who will be watching you in Lille? Or maybe around the world?
Well, we need. We're going to go through some very, very difficult times. They're very difficult times ahead, and I say this with a painful feeling in my stomach. So there is, I already referred to it, there is the geopolitical superpower confrontation between the US and China, which will affect us all. We'll have to take side in this. This is a confrontation that is fought that you see at many different levels and in many different areas, but also very much in the trade field. So to keep that confrontation under control, confrontation which will be with us for decades, so it will even survive your generation, but to keep that confrontation under control is a first challenge. Second challenge is the environmental sustainability of economic activity, and therefore also trade. And then we're thinking about, we very briefly talked about the fishery subsidies negotiations, but of course the much bigger problem is global warming. Many of the measures that could be taken and that should be taken with regard to global warming have trade elements, trade components in it. And then a final challenge is we've seen over the last decades, we've seen an ever-increasing digitalization of economic activity. There's now much more talk. Even I shop online. And I'm not the most. E-commerce has taken off. People are talking about 3D printing, manufacturing. Yeah? Now I sound as if I know what it is. I don't, but I do appreciate that it may upset all our production systems. It makes much more sense to bring back certain production that used to be sent to developing countries. No, you bring it back because you've got here a robot, a 3D printer that makes it very custom. Anyway, no. Now you see that I don't really know what I'm talking about. No, but seriously, I did not mention the COVID crisis because I think that although we're not out of the woods yet, I think this will pass. We should prepare for other pandemics, but this will pass. But these three, they need the next generation of young people that dedicate themselves to what is a very technical field of international law. But we so desperately need lawyers that either in government service or for private law firms or for industry associations, NGOs, that get on top of these issues. And that requires specialization. Now, if I can throw in a commercial here, the World Trade Institute in Bern has perfect master programs to prepare you for this. But I apologize for the commercial. Please, this is a fascinating and very important field of international law, and it will remain so for many. And my generation tried, but unfortunately, we're stuck where we are now stuck. And so it's your generation that will have to bring salvation.
Thank you very much, Professor, for having us.